Hi, Tony.
Hi, good morning. Is that
Uh,
Nkululeko?
Yes, are you well?
I'm well, brother. How are you?
Good, 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 good. I was wondering if we could do a dry run quickly, but at least raise the problem and how I can assist given all the tasks that I need to do during the
No, I
meeting.
understand you're busy, my brother, so absolutely no pressure. Thank you for offering. What I do want to do, man, is because I'm just so useless with Zoom and stuff. So
Uh,
I'm going to do my presentation, but I'll tell the committee up front that I'm unable to flight my presentation, but they have copies with them so they can work through it. But I don't want to run the risk of having to try and flight it and then running into all kinds of technical issues.
uh, okay, I'll also check the traffic on our side because I need to admit people and all that. I'll check the traffic. If nothing is happening on my side, I will try and fly the presentation for you. Yeah.
All right, that would be appreciated, but don't feel too much pressure. I'll tell them that. But yeah, that will be a bonus for them.
Okay, cool.
Somebody must send me on a workshop for Zoom soon, I think.
Okay, no problem. Thanks for returning.
Thanks, Nkululeko. See you later. Bye.
Okay, cheers. Bye. Mr. Swart, is that you?
Yes, sorry, I just wanted to send you a message. My name on the screen appears as JPMWKJ. Can you maybe just correct that?
I'm busy with that, sir. Thanks.
Thanks, man. I don't know why, because it happened previously also.
Yeah. No, it's cool. It's cool, Mr. Swart.
Thanks.
Recording in progress.
Good morning, everyone. Um,
Morning, Chair.
Good morning, everyone. My members, stakeholders who are present, National Treasury and SARS, officials of Parliament, led by Ndate Mangweni. As well, as we all know, we are starting our public consultation process on the 6 tax bills today, honorable members and stakeholders. The committee got a briefing last week and engaged with the National Treasury and SARS. Today is meant for the public to make an oral presentation. We will also give time to National Treasury and SARS to make preliminary responses. We will continue with public consultation process again on Friday when National Treasury and SARS officially respond to submissions and take us through the bills clause by clause as agreed last time. We plead with stakeholders to avail themselves on Friday meeting as we are going to give them more time to engage with National Treasury. So I think, honorable members, those are my opening remarks, and without wasting any time, I'm going to check with the Ndate Mangweni, just take us through if there is any apologies that you know or that you have received, so that we can request the stakeholders to do the presentations.
Morning, Chair. Morning, members and stakeholders. We received 2 apologies, Chairperson, from Honorable Brits and Honorable Lehwase. They are coming to the meeting, but they will arrive late, Chair. That's all on my side, Chair. Thanks.
Thank you. Can you flag the agenda so that we can see?
Can you confirm if it's appearing on your side, Chair?
Okay, yes, I can see that. Can we check if COSATU is ready? We have 4 stakeholders. That is COSATU, Association for Savings and Investment South Africa, that is ASISA. Then the Institute of Retirement Fund Africa, IRFA, then the webinar and the Wenzel. So I think the program or the agenda is clear. I'm not going to, I don't want to be harsh or rude to my stakeholders. So, but we managed to give you time to say you are presenting from this time to this time. So I think we are almost there. Can we allow Comrade Pax to start with the presentation? I think it's him. I haven't seen another name here.
Good morning, Chairperson.
Yeah.
Good morning, Chairperson. Good morning, comrades. Good morning, colleagues. I just want to say, Chair, that I must apologize for Comrade Parks. My name is Tony Ehrenreich. I'm his deputy, and I will be doing COSATU's presentation today.
Okay, Comrade. Okay. No, it's fine, Comrade.
Thank you very much, Chair. I just want to at the outset say, colleagues and comrades, that I have a bit of a problem with sharing my presentation, but I know that it has been circulated to you, so I ask that you kindly follow your copies, and I will take you through a brief presentation of our report. Chair, today we want to...
Can I first check if there is anybody who's having a challenge? Maybe you can also send to Ngululeko to flag it for you if you don't have a problem with that.
Yes, thank you, Chair. We have sent it to Nkululeko, and
Yes.
if he's able to.
Chair. And that Honorable Siwisa.
Can we get the face for the name?
No, it's fine. Comrade Tony.
Yes, comrades. I have put on my face, but I must just say that my data and my connectivity is not great. And
Yes.
that's why I asked that I be allowed to put my camera off so that we don't have challenges in the presentation. With
No,
your
it's
permission.
fine. You can put it off. It's fine. Let's have, I think everybody have seen your face here.
Thank you.
The presentation is on the screen. Thank you.
Thank you very much. So thank you, colleagues. I then proceed with the presentation. And the first slide is the introduction. And really what we're saying is that we want to table our submission today on the Revenues Law Amendment Bill and the Taxations Laws Amendment Bill. And we're doing that presentation to yourselves on the 26th of November. By way of introduction, COSATU welcomes the opportunity to present proposals to the Standing Committee on Revenue Laws and Taxation Laws Amendment Bills, covering the two-pot pension reforms, value-added tax, and the fuel taxes. COSATU has intimately been engaged in the development of the two-pot pension reforms since it was first tabled to the Treasury and Parliament in the mid-2020s. Whilst we welcome the progress we have made, we believe 4 urgent matters must now urgently be addressed in the 2024 Revenues Law Amendment Bill. We go to the next page. COSATU is equally dismayed that Treasury is silent on government's repeated 2018 and 2022 opening of Parliament address to review the fuel tax regime, as well as the basket of goods exempt from value-added tax. Similar commitments were made to review this basket of goods by the 5th Parliament, and we haven't been able to pick up that discussions in a meaningful way. Workers are drowning in debt, Chair, and struggling to cope with the rising cost of living and just keep the pots cooking in these difficult financial times. Government has made a progressive commitment to review the fuel tax regimes and the basket of goods exempt from VAT. We believe this must be honored by the Treasury, and that has to be facilitated by a detailed engagement. And it's in that regard that we submit here, and it's the following few slides, our Revenue Laws Amendment Bill proposal, and that is on page slide 5, and I now proceed to slide 6. On taxation, Chair, workers, especially low income, are deeply aggrieved at having to pay tax on pension withdrawals, in particular the once-off relief and withdrawals from the savings pot. Workers feel that government is profiteering from their misery and indebtedness caused by a stagnant economy that they are not responsible for. Pensions, including the once-off relief and the saving pots, are workers' hard-earned wages, and it must be utilized and be accessible in a way that helps them to address their financial challenges. So it is important to remember that the point of the relief that we spoke about in 2022 was to make sure that it alleviates workers' indebtedness. We must further reduce the taxes on low-income earners so that provides some additional relief. Now, COSATU's proposals on taxation is included on slide 7. And there we ask that no taxation on early withdrawals be affected for workers below the income tax threshold that exists at the moment. Next point is withdrawals by low and middle income workers should not push them into a higher tax bracket. So we must ensure that there's a way to deal with the tax creep that's a consequence of the additional income that workers receive as a result of them applying for their benefits. The first withdrawals by low-income workers, we believe and we request should be tax exempted. The withdrawal below 30,000 should also be tax exempt, or low-income workers should be taxed at a lower rate, example, at 10%, as opposed to the other existing tax rates. On job losses, which is on slide 8, we believe that the request that the vested rights allows workers access to their pre-September pensions through retirements, retrenchments, dismissals, and resignation. So that's the pre-September arrangement that exists in the laws. Under the new law, workers only have access to their preservation pot through retirement. That has to be addressed though, and it's got to be addressed by making sure that there's a discussion and agreement reached with Treasury for workers who lose their jobs to continue to have access to their entire pension funds. Workers who are unemployed will struggle to find a job at an advanced age in an economy with a 42.6% unemployment level. And as we know, South Africa doesn't have a comprehensive social security system, and many struggle to be able to access the relief that the UIF provides, even though that's a limited relief. On job losses, we cannot sustain a scenario where workers lose their jobs and despite having substantial funds saved in their pension funds, cannot access it and would thus face the danger of losing their homes because they can't settle their bills, lose their cars, or take food off the table from their families. It is thus critical that this matter now be resolved as per the agreement that had existed with Treasury. Our proposals are as follows: that workers be allowed to access their preservation pot in the event of them losing their jobs. We go to slide 10. Slide 10 talks about the vested rights transfer pot. Whilst appreciating that the up to 30,000 Rand immediate relief for many workers, this isn't enough to make a meaningful impact upon the high level of indebtedness in our society at the moment. Free up income to take care of the families of workers, or remove the temptation to resign from their jobs in order to cash out their pension and in that way settle large debts. Workers would need larger amounts to escape their debts, and it's in this regard that we believe that pension funds and government, who are worried about the impact on the resignations on savings, should help us to work out a fair compromises needed to give workers more meaningful relief and to boost the savings culture within the economy. We then go to the next slide, which is slide 11. And this is COSATU's proposals for the vested rights. We believe that workers must be allowed to transfer the rights, should be allowed the right to transfer funds from the vested right pot to the new two-pot regime. This should be voluntary, and this transfer should be based upon 2/3 going to the preservation pot, which workers could access upon retirement or losing their jobs, and 1/3 going to the savings pot, which they could be accessing annually. The next point is that workers must be allowed to choose how much to transfer from their vested right pot to the new two-pot regime along the 2/3, 1/3 split. And this, Chair, is really to take forward the principle of this being deferred wages from workers, and that it must be available more flexibly so that it serves the financial requirements that workers have, while at the same time being mindful of its significant contributions to the savings culture in this country. Our further proposals on the vested right is, so for example, if a worker had 300,000 Rand in their vested pot, they could decide to transfer 150,000 to the two pots, with 100,000 going to the preservation pot and 50,000 going to the savings pot. It would be workers' choice, and the two-pot formula would apply. This, Chair, would contribute to the flexibility and would give workers more substantial relief, boost savings for retirement, and allow workers to decide what best support they need at different times from the finances that they have available. Slide 13 talks about education loans. Workers at the moment can use pension funds as collateral for home loans, as these are considered to be investments. We thus ask that education loans along the same line should be considered as investing in a worker or their child's education, and this is an investment in their career, their earning potentials, and their future retirement savings. Many workers cannot afford education fees or don't qualify for NSFAS, whose qualification threshold hasn't been adjusted in the last few years. The COSATU proposal is as follows: that workers should be allowed to use their pension fund for education fees as per the home loan provision. We then move on to slide 14, and slide 14 deals with the Taxation Laws Amendment Bill. Slide 15 is our first substantive comments on this. On the fuel tax and the VAT exemptions, COSATU is dismayed that Treasury is silent on repeated commitments by then Minister of Energy in 2018 and the current Minister of Finance in 2022, and most recently the President's opening of Parliament address in July 2024, where the undertaking was made to review the fuel tax regime and to review the basket of goods exempt from VAT so that this is able to provide additional relief to workers struggling with low incomes and rising cost of fuel, food, and the cost of living generally. Similar commitments, Chair, was made to review this basket of goods by the 5th Parliament. Workers are now even further drowning in debt and struggling to cope with the rising cost of living, so these undertakings are even more urgent to be considered for implementation. On slide 16, we say that the government had made progressive commitments to review fuel tax regimes and the basket of goods exempt from VAT. We believe that this must now urgently be honoured by Treasury. This has been raised repeatedly, and even though there's been some discussions in NEDLAC on these attempts to deal with the impact of rising cost, we felt that Treasury was not as forthcoming in these engagements, and we could not make progress towards an agreement that brought immediate relief to workers and to the economy. COSATU's proposals are thus as following: that Treasury must return to NEDLAC and engage in good faith on reviewing both the fuel tax regime and the basket of goods exempted from VAT so that this is able to provide additional relief. Clause 17, COSATU hopes its proposals will be considered by Parliament, and we hope that this committee will add their voice to encouraging Treasury and finances to engage more urgently and seriously on this matter. They are too urgent and important to be delayed or be dismissed as not being possible for implementation in 2025. These are not new issues, Chair, and were raised during extensive engagement with Treasury and many other forums. The Select Committee in Finance in May 2024 on the Pension Funds Amendment Act mandated Treasury to review and to revert back on the two-pot pension reforms. We go to slide 18, which is our final slide. So in conclusion, Chair, it is critical that these proposals be engaged, and it must be speeded up so that it can be resolved in a win-win solution. COSATU is requesting urgent engagements to resolve them. We agree that the need to review and reduce fuel prices and expand the basket of goods from VAT have been raised many times in Parliament, with calls made to Treasury to see how we can find urgent relief to workers and the economy. We believe the time is now right, Chair, for us to find solutions that are mutually beneficial and can be urgently expedited and implemented to ensure that we bring the relief to workers and working class families who are facing immense difficulties with rising cost of living, rising fuel prices, and the reduction in employment opportunities. These matters, Chair, are urgent in our view. They are desperate to respond to the plight to our constituency, and we ask that this committee consider it favorably and assist us in moving it through the parliamentary and government process. Thank you very much for the opportunity for this presentation today, Chair, and over to you.
Thanks, Comrade Tony. Asisa.
Good morning, honourable members and colleagues. Just want to share the presentation. Are you able to see the presentation?
Yes.
Okay, thank you very much. Good morning again. I'm Audrey Messerschmidt from the Association for Savings and Investments South Africa, ASISA, and I am doing a presentation on the Revenue Laws Amendment Bill. Can you see the pages changing? Just want to check that it is moving.
Yes, Audrey, it is moving.
Okay, thank you very much. Who is ASISA? ASISA represents its members, which are retirement fund administrators, investment managers, long-term insurers, collective investment schemes, and these are all service providers to retirement funds. Our members understand and have implemented the administrative systems and other business processes that the two-pot system requires. They interact regularly with retirement fund members and understand the difficulties that these individuals often face. The CISA members welcome the introduction of the two-pot system. We believe that it will ultimately have a fundamental positive impact on the capital available to fund members on retirement. Many of the amendments to the Income Tax Act proposed in the 2024 Revenue Laws Amendment Bill are necessary and welcomed. However, some concerns remain. Just a summary of the concerns. Most amendments do require retrospective application, given that the deadline of the 1st of September 2024 has passed. But retrospectivity is not appropriate for certain amendments, which require prospective application. We believe there are drafting errors in the bill that is before you. In some cases, the drafting does not reflect the changes agreed to by National Treasury in their responses to the National Assembly Standing Committee of Finance in October. And there is an amendment in the Revenue Laws Amendment Bill that doesn't align with an amendment to the same provision in the Taxation Laws Amendment Bill. We believe there are some drafting corrections that are necessary for consistency and some typographical errors that need correction. On the retrospectivity of certain amendments, there are two problematic ones. The first is the seeding date and the calculation basis for Provident Fund members who were age 55 and older on 1 March 2021, the so-called T-Day, and also with reference to the opt-in for Provident Preservation Fund members who were 55 and older on 1 March 2021. Several funds have had rule amendments approved by the Financial Sector Conduct Authority, which may now be rendered non-compliant by the retrospective application of certain of the amendments. I'll deal with the first issue, which is the seeding date and calculation basis for preservation funds. The bill states that where Provident Fund and Provident Preservation Fund members aged 55 and older on 1 March 2021 elect to participate in the two-pot system, the calculation of the seeding amount must be based on the value of the member's vested component as at 31 August 2024. That changed the calculation basis from the February 2024 draft bill, which provided for the value to be based on the member's vested component, the calculation to be based on the value of the member's vested component on the last day of the month during which they make the election to opt into the two-pot system. System changes, communication to fund members and rule amendments have been made and approved by the FSCA, according to the fund's understanding of what the legislation was likely to require. Some funds opted to base the calculation on the value at 31 August and others on the last day of the month during which that fund member made the election to opt into the two-pot system. Having to backdate the seeding calculation to 31st of August could be problematic in cases where the member has since taken a withdrawal from the vested component, or there was a Section 37D claim after the 1st of September, and there could then be insufficient funds left in the vested component to provide the seed capital amount as at 31 August. This situation cannot be undone retrospectively. Treasury responded to the Standing Committee on Finance in October, indicating that funds should have the option to choose which approach to follow, essentially whichever version they communicated and are included in their rules should remain valid. However, the wording in the Revenue Laws Amendment Bill does not reflect this, and a drafting correction is therefore required. If this correction is not made, then the amendment can only be effective prospectively. On the opt-in for Provident Preservation Fund members who were age 55 and over on 1 March 2021, The bill states that only if a member is still a member of the same fund that they were in on March 2021 will they be excluded from the two-pot system. They always have the option to opt in. However, in the 2024 Act, the drafting could be interpreted to mean that such a person did not have to be still a member of the same Provident Preservation Fund that they were in 2021. Again, different funds drafted their rules according to the understanding, and their rules have been approved by the FSCA. Systems have been built and communication to fund members have been based on the approved rules. The Act should not be amended in a way that makes actions taken according to the approved rules unlawful, and this is another situation which cannot be undone retrospectively. In this case also, we believe the fund should be given the option to select which approach they will follow, whichever of the two versions they have communicated to their members and incorporated into their rules should continue to be permissible. Treasury did not respond to this specific issue in October 2024, but we believe the same optionality could be applied in this case. Alternatively, the amendment should be effective prospectively. Then on the issue of preservation funds and a change in tax residence, withdrawals from those funds in the case of a change in tax residence is subject to a 3-year waiting period on preservation fund members where the member has changed tax residence. This should be amended to provide that only where that member has already taken a once-off withdrawal from the preservation fund will the 3-year waiting period be applied. This is a current vested right. Treasury responded that they agree with that proposal, that the vested right should be protected, but the wording in the Revenue Laws Amendment Bill does not reflect this, and a drafting correction is therefore required. Then there's an amendment in the Revenue Laws Amendment Bill that is misaligned with the same provision being amended in the Taxation Laws Amendment Bill. That is the definition of retirement annuity fund, and this error needs to be corrected. In addition to those already covered, we made various drafting proposals to correct certain drafting in the bill to ensure consistency, as well as to remedy typographical errors. In conclusion, the two-pot system has introduced a significant change to the retirement system in South Africa. CISA members continue to support the broad principles and aims of the system. Some refinement in the current income tax legislation and the amendments proposed in the bill is required, as I've highlighted. These concerns are dealt with in detail in the written submission sent to this committee. Thank you.
Thank you, Asisa. Irfa.
Good morning, Chair. My name is, and other committee members. My name is Nancy Andrews, and I represent the IRFA, the Institute of Retirement Funds Africa. I'm going to share my presentation. I hope it works.
How do you pronounce it?
It's IRFA.
Okay, thank you.
Please let me know if you can see my slides.
We can see it.
Thank you, Chair, and thank you for the opportunity to present this morning. The Institute of Retirement Funds Africa represent various stakeholders, most of whom actually include members of retirement funds, and retirement funds themselves. Our submission to Treasury on the Revenue Laws Amendment Bill is not far off what ASISA's submission has been. Sorry, I'm just trying to get through the technical issues here. Again, supported what ASISA's actually said is on the seeding date for the Provident Fund members over age 55. Importantly, I think the understanding that we received through the response documents from National Treasury were that there would be flexibility created and it would be dependent on how the rules were registered. We didn't see that reflection in this current version of the bill. We saw it go back to a previous version of the bill, which was issued on the 20th of February this year. We have proposed wording to actually allow for this flexibility, and we would appreciate if that wording is considered. If that is not, then again, we support prospective any amendments for a different version to be prospective, because it will actually allow for retirement funds enough time to actually amend the rules accordingly. Our next issue, which is an issue on transfers, and particularly around the issue on retirement and the purchasing of annuities, as well as transferring when you actually resign from employment. Our current law actually allows us to actually transfer between multiple funds. And it seems like in this new bill, it's now restricted to just one fund, and all components have to actually move to that fund if a transfer election is made. We request that current vested rights that allows for transfers to more than one fund in the same proportions of each component be allowed going forward. And we have suggested recommended changes on those for that wording as well.
Chairperson, if I may interject, please.
Honourable.
Thank you very much, Chair. Ms. Andrews, your shared screen is not following your movements. So if you can maybe just make sure that while we have copies of it, this meeting is being presented. So we're not seeing the slides moving in concert with what you're saying, which is important for people that might be watching online or at home. If we can just get those talking to each other. Thank you, Chair.
Thank you, sir.
If I may, I can share the presentation. Which slide number you were in?
Yes. Thank you. Thank you, Ntate Mangu.
I'm actually on slide point 3 of the presentation. Which is slide 5.
Hello?
Hi. It's slide 5.
Slide 5, okay, cool. Slide 5, okay, there we go.
Thank you. Apologies, members of the committee and chairperson. Again, some of the technical corrections that we've actually picked up in the legislation, we've made comments, we've made suggestions for this, particularly around the issues of aligning to the sections in the Pension Funds Amendment Act that was issued this year, so that it actually corresponds with each other. I think that in our previous submission, and Treasury has accepted that there were changes that needed to be made, but some of the changes didn't follow through. So we've highlighted that in our written submission for consideration by National Treasury. The next slide is on the vested component on preservation funds. And I think Asisa actually alluded to this particular issue on preservation fund, Provident Preservation Fund members who have not accessed their one withdrawal before they cease to be residents. This is currently in the legislation, and it is a vested right that they can access one withdrawal pre-retirement. We've seen that the change came through for the occupational funds, which allows members in an occupational fund who cease to be a resident to actually not wait 3 years to withdraw their vested component. And we believe that the same provisions should actually apply to Provident Preservation Fund members who have not exercised their one withdrawal. Chair, and I think that's all from us, but just to actually acknowledge National Treasury for their consultation, for their efforts in consulting with the stakeholders of this industry, and for actually taking into consideration previous comments that were made through the Institute of Retirement Funds Africa, and and asking that in any further engagements that we be included as they always do. Thank you, Chair.
Thanks very much, Eva, and you're so sweet and short. Whereby and Wenzel? Do you have whereby and Wenzel? Dr. Mangwen, do you have whereby and Wenzel?
Chair, I don't see them here in the platform.
Okay. If they are not here, then it excuse me.
Can I suggest, Chair, that we move on? I'll try and contact them offline and see what is happening.
Yes, yes. If not, then we can now give opportunity to members of the committee to interact with or are we going to give the National Treasury for the preliminary response before we give the members? Can we go to the next item, which were for the National Treasury and SARS to give us the preliminary responses in terms of the agenda? National Treasury.
Good morning, honourable members, honourable Chair. Thank you for giving us some initial time for initial responses. I mean, we can provide more detailed responses when we do our feedback session later in the week. Just as an initial response, I think we note a lot of the comments from Kasati in terms of making further statements on the zero rating for VAT and on fuel levy reviews. We wouldn't be able to do those in these tax bills. These tax bills are intended to implement the budget announcements that were made by the minister in the beginning of the year. I mean, what we can say is that we have been working on the zero rating of VAT, and we've been doing our own analysis, and that can hopefully feed into any potential announcements that the minister might be able to make in the February budget next year. The same would go for any work that we are doing on fuel in conjunction with some of the other departments which are also responsible for fuel pricing. So we're responsible for the levies on fuel, whereas the pricing aspects are the responsibility of some other departments. On the amendments that Casati have made and proposals on the change in the two-part regime, so we are looking at those issues. Again, we would need to, make an announcement through the minister.
Chris, can
Yes,
you please?
Andre.
Okay, no, just hold. I see the hand of Honorable Sivisa. I'm not sure if the legacy hand or what.
No, Chair, I was going to make comments, but you said the National Treasurer must come in. It's fine.
Okay. You can continue, please.
Hi, Chair. Sorry, Chris. Weber and Wenzel has
Yes,
joined.
I'm sorry. I had a client meeting and it just ended. If I may make my submission, this is regarding the amendment to the definition of company. If I can share my screen. Apologies to everyone. The schedule did say 10:50 and my meeting ran over. My apologies.
Yes, you can share your screen.
I'm going to share the screen, and I hope I am sharing the right screen. And so what we have in front of us is the amendment. The amendment provides that a portfolio of a hedge fund collective investment scheme will be inserted into paragraph E of the definition of company. So this would mean that a portfolio of a CIS in hedge funds will be included in company, in the definition of company. And what's important here is that a company, and this is the portfolio carried on outside the Republic. So this is your foreign CIS in hedge funds. So that's the proposed amendment. I also want to draw your attention, in this definition, there is reference to CIS in participation bonds and also portfolio of a CIS in securities. And now we're adding portfolio of a hedge fund collective investment scheme. I think what we wanted to just clarify is because we have we have that amendment, and we have proviso D of the CFC definition in section 9D2, where proviso D doesn't have the corresponding amendment to include the foreign CIS in hedge fund. So what I've shared now is the written submission. And basically we have a foreign CIS in hedge funds that is included in companies, but then proviso D in section 92 didn't have a corresponding amendment. So we're wondering if there was perhaps an error, because this has pretty serious implications for foreign CIS and hedge funds. Because if we look at section 9D, any sort of resident taxpayer which has more than 50% participation rights in a company as defined, or more than 50% voting rights in a foreign company, then that foreign company potentially becomes a CFC. Proviso D was inserted to remove that uncertainty for South African resident fund of funds. So let's use an example. If you have a Satrix MSCI unit trust in South Africa, and they make investments into a foreign fund, and this foreign fund is a specific fund which has basically this resident Satrix fund holding more than 50% of the participation rights to dividends, economic rights, or the voting rights in that foreign fund. Proviso D was introduced to remove the uncertainty whether or not this Satrix unit trust is now a CFC or not. So Proviso D inserted references to say that when you consider 92, it is not necessary to consider the participation rights and CRS in participation bonds as contemplated in paragraph E2 of the definition of company. So that was clearly in the EM of 2016, which introduced 9 Proviso D. It's to remove that uncertainty. If you are a South African unit trust and you invest in a foreign CIS, it's not necessary to consider whether you as the South African unit trust, if you are a CFC. So now we have this proposal where portfolio of a hedge fund CRS is inserted in the definition of company, but the proviso D in section 9D2 doesn't have this corresponding insertion. So we are very concerned and we were wondering if that was an error and an omission, because this has serious implications to South African unit trusts that have this types of investments into foreign CRS funds. Because firstly, it means they don't have that protection offered to section 9D, 9D2 Proviso D. Secondly, if they do become a CFC, it's sometime when the bill 2024 is promulgated, wherever that date is, it becomes, they cannot prepare, they don't know in advance whether they are a CFC or not. So there's a lot of uncertainty. So it becomes very urgent and potentially a big issue for this foreign CRS and hedge funds, which is probably, sorry about that. So it was probably an omission. And we were wondering if it is possible that the effective date of this amendment is then postponed to potentially 1 March 2026, so that we can then have this error corrected in the 2025 tax bill process. Thank you very much. Any questions?
Where about and Wenzel?
Yes.
Hello. Is it Johnson?
Yes, I'm here.
Okay. No, it's fine. You are not chairing the meeting. I'm the one who's chairing. So you just do the presentation. We'll come to the questions session. Questions and answers session. So colleagues, let me start by apologizing to the National Treasury for the interjection that happened earlier. So we sincerely apologize. Chris, please, it's not something that it was happened intentionally. So can you please continue with the preliminary response, Chris?
Thank you, Honourable Chair. It's perfectly fine, not a worry at all. I think I was onto the point on Kasati's proposals on the new amendments proposed for the retirement system. So we're going to look at all of those amendments. At top of mind at the moment has been trying to get the smooth implementation of the two-part system through. I know some of my colleagues are busy presenting to the Standing Committee on that exact issue and on the fees associated with the two parts, as well as employer contributions to the funds that might not have been made. Our focus is trying to sort those issues out to get the two-part system to be working in a smooth and correct manner so that the members are treated appropriately. We will look at those other amendments, however, and we can raise some of those issues with the Minister to see whether we can make further amendments in the future. We have had, I think, one engagement with Kasati previously where these were discussed, and on some of the points, we did think there was potential for movement, so we can consider that further. On the other amendments and the presentations made on the Revenue Laws Amendment Bill and this last presentation, these are quite technical, and we will have to go away and look at those quite carefully. There is an Annexure C process, which we do run in December each year, where we ask for these technical amendments to the bills and to the acts, that we can then make adjustments if required. So we can have further engagements with the stakeholders on those, but we can potentially provide more detailed responses in the further response on Friday. And Shlanshla, Warren, France, would any of you like to come in as well if I've missed any issues?
Okay, can we go to SARS? Ronel? Is it Ronel? I've got Ronel and friends. I'm not sure who's going to do the response.
Thank you, Chair. Franz Tomasek, this side. Good morning to the Honourable Chair and Honourable Members. None of the matters that were raised this morning dealt specifically with the administrative issues that SARS presents on generally. So I don't have anything to add at this stage. Thanks.
Okay, thanks very much. Can we now allow honourable members to interact with the presentation? I'll check. I'll check the hands. I've got Honourable Suisa, Honourable Ryder, Honourable Swart, then Honourable Mumalo. Welcome, Honourable Depase. I think we have received your apology, and also Honourable Majora. Welcome. I'm not sure if that was apology. Honourable Suisa.
No, thank you, Chair. Chair, mine is just going to be short. I hope my network doesn't fail me. I don't know what's going on. I can't hotspot, and I'm struggling to connect to the network of Parliament. Mine is only a concern about the workers' issue and the suggestion that is made by COSATU that whatever savings that employees have made because their children don't qualify for NSFAS, they must take their savings as surety when they go to make a loan to take their children to tertiary institutions. The problem would be what happens in a family whereby there are 5 children in the house. And it means that only one child will be catered for, taking into consideration the amount of money that employees are getting. And I think we also agree with COSATU that to say that the wages are too little to do anything about it, which means that people are living from hand to mouth. They've spoken on the issue of exempting the food basket, which is a good thing. But my main problem is when it comes to tertiary and children of employees that are already paying taxes do not qualify to be beneficiaries of NSFAS. And in the same breath, it means that despite the fact that their parents are paying taxes, they will not be able to benefit from the same taxes that their parents are paying. Now the parents have to take their savings or their provident funds to take their children to school, which is not even going to be enough, taking into consideration how expensive education is in tertiary. So rather, I would have loved to hear a contribution that says that all children must be beneficiaries of NSFAS. Most parents are making savings or they take their pension funds to build houses, most of them. They say that if I can build myself a decent house, I'll be happy. Now COSATU is saying that that money should be used as surety when a parent goes and makes a loan to take their kids to school. What happens in a household whereby there are 5 children? Which child is going to be given the pension money or the pension fund to go to school, and which ones? Because you can take one child, take the money, take one child to tertiary. What guarantee do we have that that child after tertiary is going to get employment so that he or she can take her siblings to school? So I think we need to relook the issue of NSFAS and children of employees not qualifying to be beneficiaries of NSFAS. That was my only point for now, Chair. Thank you very much.
Thanks, Honorable Sibisa. Honorable Ryder.
Good morning, Chairperson, ladies and gentlemen. Thank you very much, as usual, for the time and effort that's gone into preparing the presentations and presenting them to our committee. Yeah, if I can start perhaps in the order that we had it, Kusatu. Yeah, well done for pushing some TA agenda points. But yeah, I believe that Mr. Ehrenreich has made an incredibly valid point, and this committee has, in the last round of discussions on the two-part system, raised concerns about the taxation at marginal rates on withdrawals from the two-part system. And while Treasury came back with some fairly compelling responses, I do think it's important to revisit the discussion, and perhaps particularly in light with the specific instance Mr. Ehrenreich raised about people that are below the taxation threshold, and where a withdrawal from the two-part system pushes them above that threshold. I don't believe that that is part of the, I don't think it's in line with the spirit or the intention of the bill or of the two-part system that has been brought in. And I do think it is something that really is worth fighting about. I think, yeah, this committee had strong deliberations on the taxation regime relating to two parts before. Treasury unfortunately won that particular argument, but I don't think the argument's necessarily over, and particularly in light with this issue of people below the taxation threshold, I think it is something that that needs to be spoken about a little bit more. The fuel tax regime, again, it's something that we've been talking about for quite some time. There have indeed been promises that the fuel tax regime is going to be reviewed thoroughly, and we haven't seen those promises coming through in terms of actual outcomes. So if Treasury can bring us up to speed with exactly what where we stand currently with the fuel tax regime review, and of course the zero rating of more primary foodstuffs. I think we've spoken about this at length, and it is something that we and COSATU certainly agree on at this point. Chair, moving on to IRFA's submission. I think IRFA, no, let's do ASISA first. I beg your pardon. ASISA, I think Old Mutual is a member of ASISA, and I had a bone to pick with Old Mutual last time that ASISA presented, because Old Mutual was wagering a battle in the media and didn't actually follow through on the media battle in terms of bringing issues to this committee. Now, that was Mr. Williamson that did that on behalf of Old Mutual last time around. And I note that there's a new battle, and it's Mr. Robert Lewinson who's waging a battle about tax regimes in the media. And it would be most useful if ASISA could perhaps engage with their members and suggest, you know, if Old Mutual has got important things to bring forward, let them come and present to the committee or brief you to do so on their behalf. We're not seeing the follow through there particularly. And I mean, an institution as large and as economically powerful as Old Mutual, I think, should have capacity to bring their issues here to committee and perhaps inform the committee members as well. And at this point, I'm going to raise a comment that is actually directed more at Weber Wenzel, but I think at all members, all presenters here today. The members of this committee are not tax professionals. We are not accountants, we are not lawyers. And so when you unpack your issues, it is perhaps useful to spend a little bit of time. You're given a reasonable amount of time to present to this committee, and it is useful to present a compelling argument, perhaps a less technical argument, but more along the lines of telling the story about what it is that your concerns are and what you're trying to achieve. And certainly, I think Weber Wenzel, your presentation today was not pitched at the right level. I do also think that when you do enter a meeting, it's polite to hear the other presenters as well, and not override the chair, but I suppose that's a matter of style. Then I think that Asisa raised a very big point, that some of the issues, and I think this was echoed by COSATU and by Weber Wenzel and by IRFA as well, that the promises and undertakings that were made in the last round when we were dealing with this, of changes that needed to be made, have not been followed through on. And I do think that Treasury owes us a response on that, and a detailed response as to why undertakings that were previously given, and there were a number of them where it was stated that it's too late to make these amendments now. We agree with them, and we will therefore bring those amendments through in the next round. Why have they not come through? I think it's very concerning, and it's something that we do need to keep an eye on, because you know, as they say in Afrikaans, beloftes maak skuld. To translate that, it means a promise leaves you in debt. So Treasury, I think you owe us a little bit of debt, a bit of repayment there, perhaps at the very least, a very compelling answer. That's my input. Thank you, Chair.
Thanks, Honorable Rada. Honorable Sart.
Chair Lady, for now I'm covered. I'm just waiting on response.
Thank you, Honorable Sivisa. Oh, sorry, Honorable Numala.
No, thank you very much, Chair, and greetings to your good self and all those who have presented and honorable members present here. Chairperson, thank you very much for the opportunity given to us to look at the issue of National Treasury and also that one of the stakeholders, and also to create a platform of stakeholders where they can be able to view their ideas and all that. It's a good thing that you have created so that they cannot be felt that they have been left out, especially with all the presenters. Let me acknowledge all of them. COSATU on the issue of the zero rate. It's true that as COSATU, their interests are on workers, but as politicians, our interests are on our community, are on our community at large, where most of the people are not working. You talk about the job losses. It's true that most people are not working as we speak. So the issue of the food basket, it's up for those communities. As much as we are advocating for them, and he is also advocating for workers, we have got a common goal to make sure that the food basket is going down so that our people can be able to access food as much as it's a food security matter. Chairperson, the other issue, I think the two-pot, we had ample time to look at the two-pot and its advantage. It's true that the two-pot assisted in some communities where they were held up in debt. They wanted to do 1, 2, 3, but unable to do so. With that introduction of the two-pot system, it has lifted some of the burden that workers are feeling. They don't have this and this. In meanwhile, they've got an amount of money placed for them. I was struggling with the Wenzel and the Weber and Wenzel with this presentation. Really, I was struggling. Maybe she was on a hurry on other things, but I managed to take the issue of the collective investment scheme, which is one of those matters that we have to look at, and also the issue of investing outside the country and to look at all the taxation. I think in my, maybe just to wrap up, I did get what he was trying to say, but not 50% of it, because this presentation was a bit fast. So like Mr. Ryder was saying, we are not tax expert, but we need to be thoroughly explained to us as to what is happening in terms of those taxation, so that we can be able to brief even someone, a layman on the street, to say this is what is happening moving forward. All in all, Chairperson, I want to acknowledge your good self for making sure that our stakeholders are having a bite on the budget and also on the taxation, whatever that is happening concerning our monies or the community money in Parliament. Thank you very much, Chairperson. Thank you.
Thank you, Committee Whip. We now go back to our stakeholders to respond to the questions or the comments from the honorable members. Can we start with Comrade Tony?
Yes, of course. Thank you very much, Comrade Chair, and thank you very much for all of those questions. I can just say that I agree with the sentiments around, so I'm not going to respond specifically to each person because there's a lot of overlap. But just to say that I agree with all of the comments by the speakers that talk about that we've got to revisit the discussion on taxation. We've got to look at the thresholds that we deal with in respect of how people are taxed. The zero rating of additional foodstuff has got to be a matter looked at urgently. The fuel tax was last reviewed, I think, about 10 years ago. There's been lots of changes in the economy. There's matters related to the road accident fund that has a huge impact on the fuel tax that also provides some low-hanging fruit that we need to look at. But it's about having that urgent and serious discussions to reflect on those issues. The only point that I want to reflect on in a bit more, Chair, is on the matter about the study loans. I agree with the Honorable Kumalo, the comrade who talks about the issues about the fact that NSFAS must be adequate to provide everyone who qualifies in terms of the defined criteria to be able to get study support. I think we're talking about instances, and so whilst we agree that we must get NSFAS working properly and effectively, we're talking about instances where people would not qualify through NSFAS, but that study should be seen at the same level of an investment as a house. And so you should be able to use from your fundings, just like you would make a decision on any other investment, to be able to use fundings for study as an important investment. And to be able to do that, you must be able to use your money, your collateral in the fund as collateral for a loan. So that's the only point that we want to stress. But we support the member talking about making NSFAS better. But where you're not eligible for that, that you'd be able to, as a parent or a child, use your pension fund stake that you have as collateral for a loan to be able to take studies also. So that's the only addition that we hope to pick up in this next round of discussion. On the points about Treasury, we'll engage a bit more detail on Friday. But the point about some of the issues that were raised, they certainly remain an ambition of workers and of the labor movement. And so we're going to be pushing hard for us to both pursue and conclude that discussions before 1995. Thank you very much, Chair.
Asisa.
Thank you, Chair. Although there weren't specific questions on the technical proposals that we've made, we tried to explain it, the very technical nature of the issues as simple as possible, but with tax laws, that is a massive challenge. I think the crux of it is just that with the implementation date being moved forward and different pieces of legislation being in different stages and members implementing based on draft legislation at that point in time, there are a couple of issues that just need clarification. We are appreciative of Treasury's engagement, but Treasury's choice of wording is not always as understood by our members, and that is why we made the proposals for clarity in our submission, the presentation, as well as the written submission. On the Old Mutual issue, ASISA is not directly involved in the operational matters of our individual members. When we do present, it is after a process of engaging with our members and agreeing a specific position. I'm not aware of the statements that Mr. Ryder or Honorable Ryder is referring to, but I will try my best to find out and engage with them and ask them whether they need or whether they feel they need to present to Parliament. Thank you.
Thank you. Is it Effa?
Yes, thank you, Chair.
Yes.
There were no specific questions regarding our submissions. Again, we want to thank the Chair and the members for this opportunity. And I think that Treasury has, like I said, have engaged with us extensively on issues. We appreciate that, and our submissions are clear enough in terms of resolving the technicalities in the legislation. So thank you for this opportunity.
Thank you, Efa.
Hello, everyone. I do apologize. I take all the points that tax has been pitched too high, and it was complicated. Essentially, the proposed amendment in the table bill is going to cause uncertainty for South African unit trusts that invest in foreign unit trusts that are similar to hedge fund unit trusts, because there's going to be a lot of uncertainty to South African unit trusts, because there's a corresponding amendment in Proviso D, which has not pulled through. And so that is why we feel this is an error, because there's nothing in the explanatory memorandum which explains the policy. It's simply one line in the clause to clause. There's an amendment. A company definition now includes foreign CIS and hedge funds. And so we request and humbly hope that this will happen, that the effective date of this proposal in the table bill will be postponed to 2026, so that in the 2025 legislative process. Otherwise, it will result in a lot of in a lot of uncertainty for South African unit trusts that invest in foreign CIS and hedge funds. So you have CIS in securities and CIS in hedge funds. That's broadly how unit trusts work under the Collective Investment Schemes the Collective Schemes Act, CISCA. But although the definition of company refers to CIS in securities, and now will also refer to CIS in hedge funds, there's no corresponding amendment on CIS and hedge funds in the Proviso D. So to sum it, there's an amendment which happened in one part of the Act, but which hasn't happened in another part of the Act, which should happen in that other part of the Act. There's no reason why there's this omission by National Treasury. We can only imagine it was an error, because there's nothing explained in the explanatory memorandum. Because of the serious impact of the omission in the other part of the Act, and that other part being Proviso D, we humbly request that this committee proposes that the effective date of the proposed amendment, which is in the table bill, be postponed until 2026 to allow this omission to be corrected. I hope that is easier to understand. Thank you so much. And I apologize to everyone for being late. I heard someone say Weber Wenzel, and so I thought I was invited to present. Really, it was no intention to be rude or anything of that sort. My sincere apologies. Thank you very much for the opportunity.
Thanks, June. NT, National Treasury.
Would you like us to come in again?
Yes, I thought maybe you have something that you also want to talk about after the members have deliberated or interacted with the stakeholders. Or if there's nothing, then it's fine.
No, we can, Honourable Chair, we can. And Shancha, you said you wanted some comments on CISA?
No,
yes, no, thank you, Chris.
Okay.
Okay, no, thanks, Honorable Chair and Honorable Members. I think there are a couple of issues as well that maybe we just needed to highlight a bit. One of them was the issue that relates to, okay, maybe let me start with what the Weber Wenzel has actually raised now. This issue, we thought that even though it's some sort of a policy, it's linked to the amendment that was made. We then thought that this issue, we can discuss it in the Annexure C process. We cannot necessarily hold this issue or delay the effective date of this amendment on that basis, because we still need to argue the points during the Annexure C process. And we have already tentatively suggested that the workshops might be on the 3rd and 4th. We just need to send now the meeting invite. So that's that issue on the portfolio of CIS that the Weber Wenzel is raising. And then the other issue, Chair, on the seeding date and the calculation basis that was raised by Assisa ERFA as well. I think we will then still have to engage with them. I think the key question as well in one of the during the workshops in July, we then had a suggestion, of course, that to say, let's go back to the February version, because the amendment, to take you back, we published the first draft in during the budget review in February. We then subsequently to that had workshop. So after workshop, we made some changes, of course. So I think maybe we can look into the wording on the sitting date, but we did make some amendment there. The other issue on the opt-in for provident preservation funds, members were over 55 years. I think the suggestion to make a prospective amendment, we can look into it. There was also another issue, Chair and Honorable Members, that related to the change of residence. That said we have made we promised to make an amendment, but we didn't. I think we did make an amendment. I think we're still going to engage Assisa and ERFA. I think the amendment was catered in another paragraph. I think maybe then we'll then have to go back and see if that wording doesn't take us there. But I think just to make a point, that amendment was made, but in a separate paragraph. There was then another comment, Chair and Honorable Members, that relates to the Taxation Laws Amendment Bill and the Revenue Laws Amendment Bill that we've made some amendment. We need to make alignment. I think the key question here is the fact that on the Taxation Laws Amendment Bill, we couldn't make any changes there because of the effective date. It's coming in late. And any changes that were made in the Revenue Laws Amendment Bill will then come in first. I think it's just an interpretation issue that we can clarify easily. And then even on other issues, of course, I think there were certain issues that the commentators made with respect to some changes that needed to be made. I think we can look at that one, Chair, and we'll respond fully on Friday. Thank you, Chair.
Thanks. Maybe I'll just come in on a couple of the other points. Thanks, Nshasha. So, I mean, there were comments here that Treasury must come back on particular issues that we said we would look at, and we are, very happy to do that. And if you can highlight which issues. I know there have been lots of discussions on fuel and what has Treasury done about fuel. In our view, we did try to do quite a lot. When the prices went up in 2022 after the Russia-Ukraine war, we implemented and that cost us 10 billion rand, which then affects the fiscal framework and is an additional amount that you need to borrow, or you need to reduce expenditure, or you need to raise taxes to fund that amount. So we provided temporary relief, which cost 10 billion. We also reduced the demand side management levy at that time by 10 cents per litre. And since then, since I think it's the 7th of April 2021, we haven't increased fuel levies at all. So there'd be no inflationary adjustments or other adjustments to the general fuel levy or the road accident fund levy. So this fuel levy issue has been top of mind. The DMRE is responsible for the fuel pricing, and there are reviews that have been taking place in terms of fuel pricing and what they can do. And on our side, we look at the revenue impacts and the other potentials. There could be potential adjustments to the road accident fund, but those are structural and organizational potential adjustments that would need to be made that then could have an influence on the road accident fund levy, which is also a broader discussion. On the tax on the pensions, our view is that it needs to be taxable. The contributions that are made into the retirement fund are not taxed at all. That were made, then there would be no tax paid at any point, not on the contribution, not on the growth, not on the withdrawal. And individuals do need to pay tax. We have a progressive income tax system, and we've tried to assist with lower income individuals, because if your income annual withdrawal is below 95,750 Rand, you don't pay any tax. There won't be any tax applicable to you. But if you have higher incomes in line with the rest of the personal income tax system, which is very progressive, then you will pay tax, and you'll pay tax according to those schedules. So if you have a high income and then you make a withdrawal, you'll pay a higher tax than if you've got a low income and you make a withdrawal, which reinforces that progressive nature of the tax. There are lots of other issues that do come to us on a regular basis, and we do look at them and we try and consider them. But if we haven't accepted them, or the minister hasn't made an announcement to say that these will happen, it doesn't mean that we've ignored them, but they have been considered, but they haven't gone through. So there is a view that, each year, and not only in these hearings, but other hearings, calling on Treasury to implement a particular policy. And it's not that we're ignoring, it's just that if we consider it and it's not a policy that we want to go ahead with, or the minister doesn't want to go ahead with, and the minister doesn't announce it, it isn't announced. But we can continue to have discussions on these, and hopefully we can have a further discussion about all of these issues on Friday. Thank you, Honourable Chair.
Thanks, Chris, and thanks, Nkandla. Let me take this opportunity. I'm not sure. Let me first check with honourable members if there is any member who also want to make a second bite. Then, before I close the meeting, can I check with honourable members if there is something that you forgot?
I don't see any hand on my side, Chairperson.
So, sorry, colleagues. Yeah, this network this side is giving me a problem. When my honourable members was talking about it earlier, I thought it's something that is not happening. Let me take this opportunity and thank the stakeholders who made the oral presentation, and also thank Busa, who only made a written submission. I've outlined already the process that we will follow in terms of what needs to be done, honourable members. My apologies. Our secretary will send out the link for Friday meeting, and also invite stakeholders to have a second bite on the bills. I would like to assure the stakeholders that the committee takes their input very serious, and would like to request that all stakeholders summarize their submission to 2 pages and send them to the committee via the secretary. This is to make sure we capture your points correctly in our report. Having said that, honourable members and our stakeholders, our beloved stakeholders, we will see you on Friday. The meeting is adjourned. Thanks very much, honourable members and our stakeholders.
Thank you, Chair.
Thank you, Chair.
Thanks,
Thank
Chair. Was that pre-recorded applause I heard? Just asking.
Thank you.
Well done.